Our next case is number 22-68, University of Florida Board of Trustees versus Carmody.
May it please the court, Christine Davis, on behalf of the petitioners. The issue before this court is whether Florida's district courts of appeal have certiorari jurisdiction to review a trial court's order denying a motion to dismiss, a defendant's motion to dismiss, when the plaintiff has failed to corroborate his medical malpractice claim with a statutorily qualified pre-suit expert. It's important to note at the outset that the case is not about the jurisdictional irreparable harm component to certiorari review. That component has long been established by decades of precedent in this court. It wasn't impacted by this court's decision in Williams, and it's not disputed by the parties in this case. That's because the legislature has set out a clear and unambiguous process that medical malpractice litigants are to follow in bringing their medical malpractice claims. The legislature has made clear that in the act, the pre-suit investigation of medical malpractice claims is mandatory and applies to all such claims. These pre-suit investigation requirements are the hallmark to the statutory framework. So the legislature enforces these unambiguous mandatory procedures through several statutes. First, the act says that no action shall be filed if the plaintiff has not complied with the statutory requirements of the Pre-Suit Act. This includes obtaining a corroborating expert affidavit from a qualified expert under the statute. When a complaint has been filed, but the plaintiff has not complied with the mandatory requirements, the statute expressly says that the claim shall be dismissed.
In determining whether or not that compliance has happened, however, it seems like while the 2013 amendments strike Section 14, which used to limit on its face the power of the trial courts to disqualify or qualify an expert witness on grounds other than qualifications in this section, it does seem that what is retained is the court's ability to strike an expert on the basis of qualifications, specifically whether or not the expert is of the same specialty. I guess my question is, do you agree that the determination whether a physician or medical practitioner is of the same specialty is a determination of fact? That is a question that the court would take evidence on one way or another, and that its conclusion on that front, whether someone is or is not in the same specialty, would therefore, whatever it is, either way, if it's supported by evidence on that, not be in clear violation of the law, like a departure from the essential requirements of the law, which is more cert in how it sounds. Like if it is the kind of question that's amenable to taking evidence, then I think you have an uphill charge on saying that it's appropriate for relief on cert, don't you?
I don't under these circumstances. So starting with whether it's a fact finding, this court in Morris versus Muniz made clear that when you are looking at whether a pre-suit expert is qualified, you look at the evidence of the pre-suit expert's qualifications, which could be his affidavit, his CV, deposition testimony, and you compare it to the statutory requirements and see if they align. So when you get into saying, especially in the medical malpractice context, it's fact-finding, and so no certiorari petition should ever be granted when there's fact-finding. That's not so in a medical malpractice case, because the statute has clear mandates, section 766, 102, 5, and 6 have clear mandates that must be followed for a pre-suit expert to be qualified. So there's no weighing of evidence, there's no discretion of the trial court anymore. The analysis is simply, what do we have that says on the qualifications of this expert, and do they align with the statutory requirements? And that's what this court said in Morris. And Morris was an appeal from a final judgment, but the analysis is the same.
I think, let me press you a little bit on this. Is it fair to say that there are already out there in the state, there are matters in which two cardiologists or two critical care physicians are in fact in the same specialty. Isn't that being litigated right now? Or is that just not litigated?
It can be litigated if a plaintiff files their claim and corroborates their claim with a pre-suit expert affidavit from a cardiologist, and then the defendant is a cardiologist, then that would be a same specialty. So that doesn't mean that a defendant doesn't challenge it or move to dismiss because they have other grounds for believing that the statutory requirements haven't been complied with, because those aren't the only ones. But it is litigated, and the purpose of the irreparable harm that's clearly established in our law is that you're not supposed to, a defendant is not supposed to have to litigate.
I'm not talking about that. Let's leave to the side the fact that we agree irreparable harm. This statute on its face seems designed to avoid, and in fact does in its textual content, avoids the irreparable harm of ever having to deal with a claim. We agree. I'm focused more on the essential departure from the essential requirements of law part of the analysis. And what I can't seem to get my head around is I'm certain that two ICU physicians, two critical care specialists, will have slightly different resumes, slightly different CVs. Maybe they are hospitalists as well, or maybe they, are internal medicine, heavy ICU docs, or maybe it's a pulmonologist who's also an ICU doc. Folks are going to litigate whether or not those are the same specialty. And I have a hard time understanding how a decision you don't like or that you do like that happens within that context departs from the essential requirements of law such that cert relief is appropriate.
Well, this court has made clear in Kaklamanos and Nader versus Department of Highway Safety, what is a departure from the essential requirements of law? What are clearly established principles of law? And a statute is clearly established law, and the violation of a statute is a departure from the essential requirements of law. So when the statute requires that you shall comply with these statutory criteria or else your claim should be dismissed, failing to do so is a departure from the essential requirements of law.
So that basically collapses into just a straight up kind of merits determination. I mean, to the extent that the whole essential requirements of law and clearly established law, to the extent that that's trying to sort of narrow the inquiry and make it different from just a straight up did the judge get it right or wrong? I mean, it seems like you're collapsing that.
Well, I'm not. So in a typical case, you would have the expert's qualifications and the defendant. In this case, for example, we had a neurosurgeon who completed the procedure, and they brought a claim against the neurosurgical ARNP. They corroborated that claim with a internal medicine outpatient doctor who had not been practicing in a hospital within 3 years, and through his testimony, which we laid out in his brief, had absolutely no experience with the clinical practice of a neurosurgical ARNP, had never supervised one, had never dealt with, he could identify a wound abscess, but he couldn't treat it. He referred those out. I mean, this is the typical case of these two experts, or this pre-suit expert does not satisfy that requirement. And so then going back to Morris, which I think is critical, is you just consider whether they align. And it is unique in medical malpractice cases because of the way the statutory scheme has been set up.
Counsel, can I just ask you this? When we're in cert land, there are always going to be wrinkles. And one of the things that strikes me about this whole body of case law, there's so much time spent arguing about whether those cert requirements are met and all that. And it seems to me that your argument about the legislative scheme and what the legislature is trying to accomplish really points to the conclusion that there ought to be a right of interlocutory appeal. I mean, then we cut to the chase. We cut to whether the statute is actually being followed by the trial courts, and I think most of the time they will, but we know sometimes trial courts make mistakes, just like sometimes appellate courts make mistakes. And so that would be the clearest, most direct means of focusing on what the legislature is trying to accomplish. Now, what am I missing when I say that?
Well, you're not missing anything, and we certainly, if Rule 9.130 were amended to allow an interlocutory appeal from these decisions, that I think would make sense. But that doesn't help us in this case or in all of the cases that have happened before or the cases that are coming down the pike now. And when you get into the requirements of certiorari, we know there's irreparable harm, so we know there's jurisdiction, and we know that requiring a party, a defendant, to go through the trial when they're not supposed to have to go through the trial in the first instance because the statutory requirements have not been followed, that's irreparable harm. So then you get to the departure of the essential requirements of law, and without having cert immediate review of an order that says denies a motion to dismiss because the court thinks that the experts are qualified, without immediate review, you're gutting that portion of you're gutting the entire act, really, because any pre-suit qualification that has not been satisfied can't be remedied on a post-judgment appeal.
Doesn't it? I mean, it seems like some of the argument between the two sides, though, comes down to whether it makes sense just to have a prophylactic rule, because in the sense of not allowing cert, because you kind of posit the sort of worst case scenario where it's obviously wrong, in which case you would hope that the trial courts would get that right most of the time. You know, that it would be an outlier where you've got people in two, like, obviously sort of categorically different specialties. And then in the case where it's kind of debatable, and maybe an appeals court would think that they would, you know, that looking at it de novo, they would have applied the statutory criteria differently, then you're really depriving the departure from the essential requirements of law element of having any force. I mean, you're basically just, you're either going to have the district courts consistently saying, well, maybe it's wrong, but it's not really wrong or obviously wrong or a miscarriage of justice, and so what's the point?
Well, I think that's where you're getting into where the courts start talking about mere legal error and not simple error, and I don't think that that applies in this context under this scheme, because it can't be a simple legal error or a not serious error, fundamental error, if your pre-suit expert is not qualified. If you haven't corroborated your claim with a qualified pre-suit expert, then you haven't complied with the provisions of the Act. And that requires, under the express language of the statute, that the case shall be dismissed, and it's established that it cannot be remedied on a post-judgment
Yeah,
appeal.
but the clearly established, I mean, that would have to relate not just to the words in the statute, but to the application. I mean, it's going to be rare that there's going to be precedent that directly addresses to, you know, a dispute over a particular expert that's so much like a clearly established case that, you know what I'm saying? I mean, it really does seem like you're essentially turning it into, you know, you're letting the irreparable harm piece where your argument is obviously strong. It's obvious that, you know, if the whole point of this is to give people the ability to do a proper pre-suit examination and to not be subject to suit at all if the criteria aren't met, it's obvious there's irreparable harm. But if the other prong is going to have any meaning at all, it seems like what you're arguing for is just a straight up review by the appeals court.
Well, I think that let me give you some examples of why that would not be true. But in the circumstances of having a qualified pre-suit expert, it is true, because that's the law and the statute is clearly established.
Well, but counsel, I just think that's not so. Because, you know, and I realize we were operating under the amended statute, and there's some, I think, greater clarity and it's limited scope, but there's still circumstances under the statute where a determination has to be made concerning whether the expert has been engaged in the active clinical practice of or consulting with respect to the same or similar health profession as a health care provider against whom or on whose behalf the testimony is offered. Well, they're all kind of like a vague, well, however you want to describe it. There's going to be, people will reasonably disagree about some of those things, right?
Right. But
and so I don't know how you can say that just kind of as some clear-cut principle of law that, you know, that we're going to, that will be amenable to the kind of treatment you're talking about under the search standard.
well, so under the search standard, when the court is the one who has to make the determination of whether the pre-suit notice requirements have been satisfied. It's not a jury question. It's not, the court has to make that determination. And so when it does that, it looks, and I keep going back to Morris versus Muniz because I think that's the most helpful way to describe it, is that the court has to be able to decide. And so you look, have they practiced in the 3 years preceding this incident? In this case, no. His testimony made clear that he did not. And if do they practice in the same, or has he had an active clinical practice in the same or similar health profession? The evidence here is that he hasn't. So basically what you're taking is the evidence and you're comparing it to the statutory criteria, which you have to do. Otherwise, it would be rendered, you'd be proceeding with pre-suit because you would have no immediate review when you clearly haven't complied with the statute. And the one thing that I'll just note as far as a prophylactic rule that you always get to go up, there are circumstances where the court has held that it wouldn't be a departure from the essential requirements of law when the law is not clearly established. And so, for example, in the Neves case, it's a 3rd District case, the issue was whether a court was required to hold an evidentiary hearing. Well, the law is not clearly established in the Medical Malpractice Act as to whether an evidentiary hearing is required. Since it wasn't clearly established, the cert petition was denied. In the Mertza versus Tromley case, they made an argument that one particular defendant wasn't noticed properly. And the law was not clearly established. His practice was noticed, and the law was not clearly established as to whether this particular defendant needed notice. That wasn't sufficient for cert review because the law wasn't clearly established. In this case, you have clear statutory requirements that say that an expert has to be qualified. If an expert is not qualified, you shouldn't have to proceed with the act. And so it is unique in a medical malpractice scheme, and with under any subsection other of 5A, B, C, or subsection 6, that you take the qualifications and you compare them, and that's what the courts have to do, and then you have to have immediate review of that. I'm well into my rebuttal, so I'll wait if you get okay.
Thank you. Adam Richardson on behalf of the respondent. I think the positions have been clearly stated in the briefs, so I'm going to just run through a quick summary of what our arguments are, because I think one of them hasn't received attention so far. The first argument, of course, is that the court should approve the result but not the reasoning of the First District's decision. In this case, I think we all recognize that the courts do have, the DCAs do have cert jurisdiction to be able to review these issues, and the question really is whether it's a clear departure from the essential requirements of the law. Additionally, our second argument is that the 2013 amendments, which are primarily deleting the similar and the specialist subsection and the deletion of subsection 14, which I believe one of the justices, Justice Curiel, might have mentioned, do not undermine Williams, which was based on just general cert principles, which the first DCA recognized, I think, correctly.
I'm glad you brought up Williams because I have some questions about it. In this case, unlike Williams, am I right that there has already been an evidentiary hearing on the pre-suit experts' qualifications?
Yes, sir, that's correct. I'm not sure if it was clear in this court's Williams decision, but it is. Okay, so there were two affidavits.
In Williams, the court concludes no cert but remands, and it says hold this evidentiary hearing and find out, basically. Here, we are, if you will, net of that evidentiary hearing already, right?
Yes.
Okay. Does that limit the applicability of Williams to our case from your perspective?
Limit in what way?
Well, I think there's an argument to be made that Williams, an argument favorable to your client, that Williams constrains us in this case. And then there is a counter argument that Williams is actually quite distinguishable. It deals with different questions, a different fact pattern. I guess my bottom line question for you is Williams very much help to you today or not? And if so, how does it help you?
I think it is helpful because if you have an evidentiary hearing, then it implicates certain standards of review, and especially the standards of review particular to cert cases. But I think that one of the problems with the remand instruction in Williams, and I don't know how directly relevant to your question is that on cert, the DCAs don't have the authority to issue remand instructions like that. They don't have, jurisdiction is not transferred from the circuit court to the DCA. So I understand that's part of the court's decision, but I'm not sure how helpful it is in saying whether or not Williams applies to our case. But the bottom line is that Williams had a much broader ruling than whether or not an evidentiary hearing was required, and if not, or if so, the implications of that. As the First District said, Williams involved just general cert principles, as I said earlier, which is the clearly established departure from the essential requirements of the law, which this court has defined over the decades as a violation of a clearly established principle of law resulting in a miscarriage of justice. And so I think that's what you need to look at there instead of particular procedural distinctions.
Can you, I'm wondering if we need to just kind of rethink how we do cert in the context of where it's coming from a trial court decision on a discrete issue to a DCA, because, just based on reading everything here, it seems like this essential requirements of law test, which is very sort of due process focused, miscarriage of justice, et cetera, it arose in the context of basically a second appeal where, you had a county court does something, circuit court does an appellate review, and then the question is it so bad that we should actually give someone two bites at an appellate apple? And in that context, that sort of test might make sense, but here, it seems like the focus is, this whole irreparable harm concept is doing most of the work, and then we get into these weird discussions in cases about the difference between something that's, wrong versus, obviously wrong, and et cetera, and I'm just not sure, whether we're even kind of down the right path on that, or if the question shouldn't be more tied to the sort of, the value add of appellate review, of, this kind of intermediate review or something. I mean, in which case, it seems like that sort of a test, maybe, in this case where there's going to be a lot of disputes about how to apply the tests and everything, arguably there's really just not much value that's going to be added by kind of interrupting the proceeding to have this review, this interlocutory thing. So do you have any thoughts on that?
The distinction between first-tier cert review and second-tier cert review is something that I thought might come up today, and something I've thought about a lot, but it requires going through very carefully the decisions of this court. But the thing is, this court, and I understand maybe you're inclined to want to revisit that, has not really distinguished between the two when it comes to the merits standard of review. In the second-tier context, I believe the test is violation of due process and departure from the essential requirements of the law. But the language is the same between the first and the second on the standard of review of the merits. And so I think the meaning should have the same. And whether the court wants to revisit that, I'm not sure this is an appropriate case for that because that hasn't been clearly raised and obviously hasn't been briefed. I don't know if this is something the court does, but if that is something you wanted to think about, then maybe supplemental briefing on that would be appropriate.
Well, I mean, but what makes the Williams case is, what makes that case kind of strange is that they basically, and the way I read it is, they essentially said they sort of drew this distinction between, you know, the procedural part and the substantive part, which I'm not sure that I wouldn't put whether the expert is qualified. To me, that could arguably be a procedural thing. You either have a qualified expert or you don't. And they essentially said, even if there was a departure from the essential requirements of law, if it's in this substantive basket, you can't review it. And that's the sense in which I would describe it as kind of a prophylactic rule of sort of saying we're not even going to let the DCAs sort of go down that path if the dispute is over the substance versus just merely checking the boxes of, you know, did you follow this deadline and is there an affidavit, et cetera, et cetera. And so it seems like Williams isn't really trying to apply the test faithfully either, because you would think that what they would have said is there may be some decisions that are so egregiously crazy, the cardiologist claiming to be an expert on, you know, whatever, that's a departure from clearly established law. But for the run-of-the-mill thing where reasonable minds can disagree, you're just never going to meet that category.
Yes, so I have 2 points on that. The first is when we're talking about Williams, we have to recognize that it's a precedent of this court, which then implicates state versus pool standard stare decisis. And
I think that's debatable, but we can talk about that.
Okay. So then I guess my more substantive response is that we actually said that in our answer brief, that there's a possibility that Williams might not be completely accurate, and perhaps the court could clarify it, which is that in, as you said, the run-of-the-mill cases, cert review might not be appropriate because there's no violation of, you know, clearly established law, et cetera, but that there are errors that are so significant that it would result in a miscarriage of justice. And in those instances, which I think would be very few and far between, it would be appropriate for a DCA to intervene, as the cases talk about in cert context.
So then let's apply that to this case.
Okay.
Your proffered expert does what for a living?
At this point, the proffered expert is, I think, more of an internist. He is not a hospitalist within the 3 years.
Okay. And the doctor or the sort of team at Shands that you sued, what do they do for a living?
The doctor under whom the ARNP worked was a neurosurgeon.
Okay. So you'd stipulate at this point, wouldn't you, that they're not the same specialty?
Yes, but that's not the provision that is implicated by this case.
I got it. I just want to make sure we're, you know, we can have, and we've had, a very edifying discussion about the cert sort of world and the statute, and that's all great. But at the end of the day, we have a case. We have a case or controversy that we need to resolve. And this case involves, I think, a very clear situation in which the proffered expert doesn't meet the statutory command. Just doesn't, right? So whatever we hold in this case, we're speaking to a case. We're not speaking to a close call here. We're not speaking to an edge case. And so since all we really have to do is speak to this case, why should we do anything more than address the fact that this is a not even close situation where you stipulate that the proffered expert is not of the same specialty, that on its face, it may be the rare case where cert is required, and if it's better for us to deal with this on interlocutory appeal in the future, that's how we'll deal with it in future cases. Why isn't that the right outcome to this case?
I have a couple of responses to that.
I figured you would.
Of course. The first is that in the petitioner's briefing in this court, they haven't asked the court to reach that particular part of the process. What they did is they asked the court to kind of address this more top-line issue that we've been talking about, cert, and then send the case back to the DCA to make that specific determination in this case.
But you've stipulated that they're not the same specialty.
That's true. However, that is not the provision of the statute that applies here. In the briefing in the circuit court, they actually said that it is 5C that applies, saying that
Well, yeah, but that's because you're talking about the nurse practitioner who works for a neurosurgeon,
Yes.
right? Okay. I mean, I think, in for a penny, in for a pound. If it's not, if your internist is not a neurosurgeon, neither can your internist be someone who, as a matter of his or her practice, oversees a nurse practitioner in the neurosurgery field, right? Okay, so the distinction you're drawing seems to me to be one without a difference.
Well, but they are distinct statutory requirements, and if you want to carry out what the legislature intended,
Well,
you
that's
can't
clearly
conflate
what we're
the
going to
two
do.
things. No, I understand that, but the statute here that applies is the 5C, and I understand that you're trying to hold a stipulation against us on one part of the statute that doesn't apply.
I'm not trying to hold a stipulation against you. I'm trying to give effect to the stipulation you've made.
Right, but
What
then
is
we,
the consequence of the stipulation?
but then we also have to give effect to the stipulation that they made in the circuit court, which is not same specialty provision that applies. It is 5C that applies.
And what is and what's the point? Like what's the effect of that? So what?
There are completely different statutory requirements. They have
Okay, so
completely
walk me
different
through
content.
what that statutory requirement does, given that your proffered expert is an internist who does not supervise nurse practitioners in the field of neurosurgery, and the people you've sued are a neurosurgeon and a nurse practitioner in the neurosurgery field. Let's deal with your statutory provision. Help me out. How do you win this case, given that?
Okay, well,
And could you say, is it under C1, 2, or 3?
I believe it's under C1, sir.
Okay.
Okay. So here it's not as narrow as the same specialty, and I think what we need to do is look at the breadth of subsection 1. So yes, it does say active clinical practice of, but there's also that clause within the commas, or consulting with respect to the same or similar health profession. And I think that reasonable people could actually disagree on whether this particular expert, in our case, does or does not satisfy that clause.
Was there evidence in the record that your expert supervised neurosurgery nurse practitioners at any point in his or her career?
No, but that is not even hinted at in the statute. There's no requirement of supervision, which I understand is the argument that the petitioners have made. It just says, in at least that clause, consulting with respect to.
Has your proffered expert ever consulted with respect to a neurosurgery nurse practitioner?
Not neurosurgery nurse practitioner.
Okay, it just seems to me like the more facts we get, the worse this gets for you, no?
No, I didn't actually think that it was that bad. I thought in reviewing the deposition testimony and the testimony at the evidentiary hearing that this would be more of a borderline case than one under the more clear statutory language in 5A. And I also would then want to point out that we go back to the cert standard, which is clearly right. And under that standard, the court has also been very clear, as have DCAs, that even a misapplication of law isn't sufficiently cert-worthy. So I think when we're talking right now about we're really talking about misapplication of law. The judge here applied the correct law.
To understand this factually, the phrase here is the same or similar health profession as the health care provider against whom, so on. So how are you defining this? You're conceding it's not the same, correct?
Yes.
So what is it? What is the similar?
That's difficult because in because in 2013 they did, or in prior iterations of the statute, the legislature had to find what similar meant, and then they took that out, and now we're just left with similar. But I believe in the previous iterations it had been something like involved in the diagnosis, evaluation, or treatment of the particular kind of care that was rendered in the case. So I don't know how far that gets me, and I'll be honest about that.
Well, I don't think that gets you very far at all. I mean, I think that if that would point, based on my understanding of the facts about your expert, that would really undercut your position, wouldn't it?
No, I don't think so, because the particular treatment rendered
What
in
do you
this
mean
care
then
was-
when you say you don't know how far that gets you?
Well, because of it being a prior version of the statute that was taken out by the legislature, I don't know how far we can rely on it, right? But if we were to do that, then it's talking about the kind of care that was rendered. And here I understand that she was in the hospital for neurosurgical procedure, but the actual care here was the postoperative wound care, or even just more generally, post-op care. And I think then that our expert would have been qualified to, qualified under the statute to offer standard care opinion against the nurse, because he does have that experience with post-operative care.
So to bring this back to the cert issue, though, the DCA felt like it didn't even have the authority because of Williams to go down. This debate is about how obviously wrong was this decision. The DCA thought that because of Williams, it didn't even have the discretion to even look at the issue, right?
Yes.
And so one possible resolution of this is to, I guess, change either, interpret Williams a certain way, or say Williams sort of took the departure from the essential requirements of law off the table for this kind of question. We're putting it back on the table. DCA, you should, apply the test.
Yes, and that gets back to what you said earlier, Chief Justice, about whether Williams faithfully applied cert law, because as the court has made clear over the decades, it's been very consistent about this, cert is a discretionary remedy. And so, I'll not necessarily play devil's advocate, but I'll take it on your terms, which is this Williams decision created a bright line rule that he said completely removed the ability of the district courts to address this issue. And perhaps that's wrong because it is not a faithful application of the court's cert precedents. But then even if the court were to kind of restore that discretion, yes, send it back, I think, to the DCA to kind of address this on the merits. But as I said before, I think in most cases, the result probably would be the same because of the standard review on the merits in a cert case. But perhaps in these outlier cases, for example, one posited by my colleague, then there would be cert relief. If there are any more questions, I know I'm approaching my time. And all right, thank you very much.
Just like to make 2 points. First, to say that the court applies the correct law doesn't help us in this situation, and we set that out in our brief, because if the court applies the correct law, that means that the court says, okay, well, we look at 766-102, 5 or 6, and we decide whether it applies. And that law is applied, but you could have, again, a neurosurgeon and a podiatrist, and the correct law has been applied because the procedure has been followed, and that clearly can't be the law and is contrary to the statute. As far as Williams, I'd just like to suggest reasons that it's incorrect. We did make an argument that the statute had changed, but Williams was based on two primary reasons. Before I get into those, it did not cite or give any kind of attention to the multitude of case law that existed prior to Williams that found there's a departure from the essential requirements of law when a pre-suit expert is not qualified. So the court in Williams kind of grabbed onto the punitive damages analogy to say that, well, in a punitive damages case, you have to determine whether there's been an evidentiary proffer to show a reasonable basis to assert punitive damages. That's not the same in medical malpractice. That's completely different in medical malpractice cases where you have statutory criteria. It's not this flexible, is the evidence sufficient to allow this claim to go forward, and whether the irreparable harm was the financial worth discovery. Here you have express language that you have to qualify under this act or else your claim has to be dismissed. So that was incorrect reasoning in Williams. And one more point, the court relied on the St. Mary's case, which was not opposite to the issue before the court there. In St. Mary's, the issue was whether the patient had ever been, or whether the plaintiff had ever been a patient at the hospital. So that was a disputed merits issue of whether the patient had ever been admitted to the hospital. That wasn't related to pre-suit. So the two main reasons that the court in Williams made this bright line rule that the First District felt like it had to follow here doesn't line up with the Act, is inconsistent with the Act, and would basically eviscerate the pre-suit requirements. So we would ask that you quash the First District's decision.
Thank you.